Good afternoon, radio listeners. Welcome all to another informative program of the Constitutional Committee. Today, we shall present a reading of the White Paper on the Road to Autonomy, ratified by the Island Council of St. Eustatius on the 11th of April 2017, along with the island's constitution as the way forward to determine the future constitutional status of the island and to give content to the political aspirations of the people of St. Eustatius. The White Paper and the Island Constitution will be made available to the public as described by law and can be downloaded from the Facebook page of the Constitutional Committee, St. Eustatius on the Road to Autonomy. As an introduction to the White Paper, we shall delve somewhat in the history of our people, our nation, and expound on the recurrent United Nations statutes throughout the document, namely Chapter 11, Article 73, and Resolutions 1514 and 1541 of 1960. This must clarify to the people of Statia that we are a non-self-governing people with the inalienable rights to self-determination and self-government bestowed upon us by the international community set forth further in international law in 1946, Resolution 9, first sitting, whereby all territories administered by an independent state, such as in our case with the Netherlands, the United Kingdom, the United States, France, Denmark, and the likes, were designated non-self-governing territories, and in so doing, all colonies were inscribed on the list of non-self-governing territories of the United Nations, Resolution 66, first sitting, 9 February 1946. In particular for the Antillean Islands, Resolution 742, 8th sitting, 27th of November 1953, Item 5, considers that the validity of any form of autonomy between a non-self-governing territory and a metropolitan or any other country essentially depends on the freely expressed will of the people at the time of the taking of the decision. Item 6 considers that the manner in which territory is referred to in Chapter 11 of the Charter, namely Article 73, can become fully self-governing is primarily through the attainment of independence. Although it is recognized that self-government can also be achieved by autonomy with another state or group of states if this is done freely and on the basis of absolute equality. This designation granted the colonies protection from abuses and violations of their universal human rights by the administering power and obligated the administering power to report annually to the United Nations on all actions undertaken to promote self-government in the territories, educational and social advancements of the people in the territory, as well as the sustainable development of the territory and its resources. This is laid down in Chapter 11, Article 73. We shall return hereto in our discourse this afternoon on this important chapter as it relates to the relationship between non-self-governing peoples and the administering power, the Netherlands. In 1942, Queen Wilhelmina, as head of state of the Netherlands in exile in London during World War II, pledged on behalf of the Dutch government to also grant the Dutch colonies, Netherlands, Indies, Suriname, and Curaçao, more autonomy at the conclusion of the war. Indonesia, making use of their right of self-determination, fought a bloody war with the Netherlands to secure their independence proclaimed by the people on the 17th of August 1945. Thus, in 1946, Suriname and the Antillean Islands were inscribed on the list of non-self-governing territories of the United Nations, Resolution 66, first sitting, to affirm the promise made to the people of the Dutch colonies by Queen Wilhelmina. One had to bear in mind the circumstances at the time in Europe. The European countries beset by Nazi occupation and domination added hereto the importance of the free colonies in the West, providing logistics for the efforts to end the war. Relinquishing the yoke of subjugation, the administering powers agreed to allow the colonies also to decide for themselves going forward. In United Nations terminology, they were granted a full measure of self-government devoid of external influences. This arrangement was formulated in Chapter 11, Article 73, which we shall read for you. Chapter 11, Declaration regarding non-self-governing territories. Article 73. Members of the United Nations which have or assume responsibilities for administration of territories whose people have not yet attained a full measure of self-government recognize the principle that the interests of the inhabitants of these territories are paramount and accept as a sacred trust the obligation to promote to the utmost within the system of international peace and security established by the present charter the well-being of the inhabitants of these territories, and to this end, A, to ensure, with due respect for the culture of the peoples concerned, their political, economic, social, and educational advancement, their just treatment, and their protection against abuses. B, to develop self-government, to take due account of the political aspirations of the peoples, and to assess them in the progressive development of their free political institution according to the particular circumstances of each territory and its people and their varying stages of advancement. To further international peace and security. D, to promote constructive measures of development to encourage research and to cooperate with one another, and when and where appropriate, with specialized international bodies with a view to the practical achievement of the social, economic, and scientific purposes set forth in this article. And E, to transmit regularly to the Secretary General for information purposes, subject to such limitations as security and constitutional considerations may require, statistical and other information of a technical nature relating to economic, social, and educational conditions in the territories for which they are respectively responsible, other than those territories to which Chapters 12 and Chapter 13 apply. In retrospect, realizing the implication laid down in the United Nations Charter, especially Chapter 11, Article 73, the Dutch government proceeded on a path to circumvent their financial obligations towards the Antillean Islands by forcing Suriname and the Antilles to agree to the Kingdom Charter in 1954, the proverbial sword of Damocles, negating the obligation of the Netherlands to report annually under Article 73E to the United Nations Special Committee, Decolonizations Committee, or C24. The premise of the Kingdom Charter was to erode the authority of the people of the Dutch colonies, namely their right to govern themselves freely without external influences. Culminating with such apprehension by members of the United Nations General Assembly, the Dutch colonies Suriname and Netherlands Antilles were taken off the list of non-self-governing territories in 1955. Resolution 945, 10th sitting, 15th of December 1955, known to us all as Kingdom Day. In order to appease the General Assembly, 2 amendments were introduced to the resolution by India and Uruguay to afford Suriname and the Antillean Islands to approach the United Nations at any time in the future, for they consider the Kingdom Charter as an instrument restricting the inalienable rights of the people of the territories to be fully self-governing, and to make known to the Netherlands that their obligations under Article 73A and D of the Charter remain in force and could be invoked by the General Assembly at any time. This amendment was accepted by the General Assembly and is an integral part of Resolution 1945. Further, the eventual dismantling of the Netherlands Antilles Constellation in 2010, 10th October 2010, or Second Rodney Day, 10-10-10, Capitulation Day, was to erase any remnants of autonomy in the islands with the annexation and integration of the 3 smaller islands into the Netherlands and granting of country status minus within the Kingdom of the Netherlands to Curaçao and St. Maarten. Doctor's vision, Doctor of Law Moises Frubencio da Costa Gomes, of a federation of 6 autonomous island nations within the Kingdom of the Netherlands, was finally eradicated by the Netherlands. It took the Netherlands near 75 years to erode the autonomy of the islands gained in 1946, Resolution 9, first sitting. Doctor died in 1966 and was spared the embarrassment to the capitulation of the Antillean leaders. The Autonomy Monument in Curaçao stands as a reminder to future generations of the autonomy lost with the destruction of the Netherlands Antilles and subjugation of its people once more. And the famous words of Queen Wilhelmina rang nou hollen, steunend op eigen kracht, doch met de wil elkander bij te staan. Although Statia voted in the referendum of 2005 to remain within the structure of the Antilles, even if this meant being the lone star in the Antillean flag, the political leaders of the day signed the Heads of Agreement in 2005 and the Slotverklaring in 2006 in good faith with the Netherlands, promising much advancements for the people and fast-track infrastructural development to abate years of neglect, also affording the 3 smaller islands 5 years to assess and to evaluate the new constitutional order. Yet, in 2008-2009, the Dutch government began deliberation, the annexation and the integration of Saba, Statia and Bonaire into the Netherlands. All this even before 10-10-10 was enacted. The second chamber passed the first reading of the legislation to amend the Dutch constitution to allow for the annexation and embedment of Saba, Statia and Bonaire in 2012, less than 2 years after 10-10-10. Thereafter, it was held up by the opposition members in the first chamber until a new Senate was elected in 2015 and subsequently passed in November 2016 by the first chamber, thus completing the first reading, despite assurances that the islands will be given the opportunity to define their political status beforehand and the implementation of the findings of the evaluation report, the Spies report. On the 23rd of March 2017, a week after the second chamber elections in the Netherlands, during the first sitting of the new parliament, Demissionaire Minister of Interior and Kingdom Relations, Minister Plasterk, submitted the legislation to annex and embed Saba, Statia and Bonaire to the second chamber to commence proceedings for the second reading thereof. A repetition of past behavior of the Dutch government throughout our history, whereby at will, the Dutch government continually reneges on all their promises and assurances to the people of the Antillean Islands, and are solidly bent to subjugate and gentrify the people of the islands, affront to total disregard toward the inalienable rights of self-determination and self-government. To subjugate means to gain control of someone, something by force, to conquer and own the obedience of a country or group. To gentrify means to change a place such as an old neighborhood by improving it and making it more appealing to people who have money. The White Paper and Constitution seek to correct the century-old deficiencies in our political and administrative system by seeking solace at the hand of the international community, as was laid down in the amendments of Resolution 945 of 1953. The foundation for an autonomous country, Sint Eustatius, must be achieved by forging compliance to international law and United Nations statutes by the Netherlands. Article 103 of the Charter bears this out. In the event of a conflict between the obligations of members of the United Nations under the present Charter and their obligations under any international agreement, their obligations under the present Charter shall prevail. Rest assured, the White Paper does not advocate for an independent state, Sint Eustatius, but rather autonomy with an independent state, the Netherlands, as defined by the United Nations Charter, to grant the people and the territory of St. Eustatius a full measure of self-government to be able to govern themselves without external influences and the free expression of their political will. Contrary to the misinformation brought forward by the pundits in our mid, we are not stepping out of the kingdom. St. Eustatius will remain an integral part of the Kingdom of the Netherlands as the forefathers intended, as citizens of the Kingdom of the Netherlands, the same political and constitutional status as the citizens and territories of Aruba, Curaçao, and St. Martin, and shall be known henceforth as the autonomous country St. Eustatius.
The White Paper. Where there is a will, there is a way. The Executive Summary. The current White Paper examines the desire of the people of St. Eustatius to achieve an autonomous political status within the Kingdom of the Netherlands, in accordance with international law and the importance of reinscription on the United Nations list of non-self-governing territories to give effect to the will of the people expressed in their 2005 and 2014 referendums. The White Paper draws the attention to the fact that stations have systematically, formally expressed their preference over the years, but instead were given a status of partial integration, public entity of the Netherlands when the former Netherlands Antilles was dismantled in 2010. The White Paper explains the governance model of autonomous country within the Dutch Kingdom, consistent with the expressed wishes of the people and in accordance with the guiding principles laid out in United Nations Resolution 1541 of 1960. Also expounded upon are the factors necessary for the internal full self-government that allows St. Eustatius to control its own internal affairs without outside interference and to achieve genuine political, economic, and social equality between St. Eustatius and the kingdom partners. The report further clarifies that the financing of the autonomous arrangement will take place within the normal budgetary process of St. Eustatius, consistent with an economic development plan, in combination with negotiable budgetary and other technical support and assistance to be provided by the kingdom government and relevant international agencies as appropriate. Accordingly, the need for cooperation between St. Eustatius and the kingdom partners based on mutual agreed terms is highlighted. The report emphasizes the importance of self-determination within the Dutch and international context. In addition to this, the democratic deficits of the public entity status and by extension similar deficits that exist within the Kingdom Charter are also examined. The White Paper concludes with an examination of the unusual circumstances surrounding the removal of the Netherlands Antilles from the UN list of non-self-governing territories, short and medium-term action towards St. Eustatius reinscription on the list of non-self-governing territories that includes a clear plan increasing regional awareness of the right of St. Eustatius to genuine self-determination. The introduction of the White Paper. The results of this referendum gave us a clear-cut indication that the majority of our people denounced the unilateral decision taken by the government some years ago. Our people detest in an overwhelming way the manner in which they were pushed into the status of public entity. Former Commissioner of Constitutional Affairs, Reginald Zandam, December 2014. The local population of St. Eustatius defines autonomy as the right of stations to decide what happens in their house. Internationally, autonomy is defined as the right of condition of self-government. Statius' yearning for self-government manifested itself in 1971, forming part of the territory of the Windward Islands. The islands' representatives fought for separation from St. Martin and the division into 3 island territories, each with their own representation in the Antillean Parliament. The right of self-determination of the people of St. Eustatius was undermined in 2010 when it was transformed into public entity in the sense of Article 134 of the Dutch Constitution, despite the consistent democratic expressions of the people to the contrary. With the encouragement of the Dutch government, the then Island Council ratified a motion to invoke the public entity status on the people of St. Eustatius. The present white paper will argue the case for an autonomous country with the Netherlands in implementation of the plebiscites held on April 8, 2005 and December 17, 2014, and confirmed by subsequent Island Council motion. The present white paper highlights some of the key democratic deficits of the public entity status, which are not in accordance with full political rights required under Resolution 1541 of 1960. Democratic deficits that exist within the Kingdom Charter will be explored. Furthermore, the report clarifies the Netherlands' fallacious argument that the territory had achieved sufficient autonomy, used during the adoption of the UN Resolution 945 in 1955 to justify the delisting of the former Netherlands Antilles from the UN list of non-self-governing territories. The white paper proceeds to explain why reinscription on the United Nations list of non-self-governing territories is needed.
Autonomy. Historical development of the dissolution of the Netherlands Antilles. On December 29, 1954, the Kingdom Charter was officially put into effect. This meant that the Kingdom of the Netherlands consisted of the Netherlands, Suriname, and the Netherlands Antilles, Aruba, Bonaire, Curaçao, St. Martin, Saba, and St. Eustatius. Each country would be autonomous in internal affairs under the new political constellation. Due to increasing dissatisfaction within the Dutch kingdom regarding the constitutional arrangement, a series of referendums were held in the early 1990s and between June 2000 and April 2005. On April 8, 2005, 76.6% of the eligible voters on St. Eustatius voted to become part of a restructured Netherlands Antilles. However, on October 10, 2010, with the dissolution of the Netherlands Antilles, the Island Council of St. Eustatius was persuaded by the Netherlands government to adopt a motion to accept the status of public entity within the realm of the Netherlands, even as this was not in accordance with the result of the April 2005 referendum. The Netherlands government accepted the motion and proceeded with the change in political status for St. Eustatius. The plebiscite of 2014 and beyond. Under increasing pressure from various civil society organizations, a petition drive was organized in 2013, during which more than 800 signatures were collected. Based on this, the Island Council of St. Eustatius was called on to organize a constitutional referendum before the 5-year evaluation of the public entity status planned for 2015. On October 8, 2014, the Island Council passed a motion instructing the Executive Council of the public entity to consult the people of St. Eustatius with a constitutional referendum on December 17, 2014. For this purpose, a referendum booklet was prepared, whereby the options provided on the ballot were as follows. I am in favor of St. Eustatius to stay a public entity. I am in favor of St. Eustatius becoming an independent country. I am in favor of St. Eustatius becoming an autonomous territory within the Dutch Kingdom. I am in favor of St. Eustatius becoming an integrated part of the Netherlands. 2/3, 65.53% of voters expressed a desire for a more autonomous arrangement within the Dutch Kingdom, rejecting the public entity status. The voters turned out estimated at 46% and was below the threshold of 60% required in the Island Council referendum ordinance, owing to complications related to the voters' registration process under the control of the Netherlands, which was confirmed by the yet-to-be-released UN report on the referendum results. Accordingly, the Island Council concluded that the overwhelming support for an autonomous arrangement with the Netherlands expressed in the 2014 referendum represented the will of the people, and subsequently adopted a motion on May 28, 2015, to ratify the results of the 2014 plebiscite, to pursue a more autonomous status within the Dutch Kingdom in accordance with the criteria set forth by the United Nations. The government's commitment towards the constitutional process was subsequently reinforced during the adoption of the motion on November 30, 2016. Unlike the Netherlands' acceptance and expeditious implementation of the 2005 Island Council motion to enact the public entity status, there has been no formal acceptance of the 2015 and 2016 Island Council motions, which endorsed the autonomous arrangement selected by the people in their 2014 referendum, despite numerous formal requests made by the government of St. Eustatius to the Netherlands government for negotiations to begin. Thus, the people are currently being governed by a status which they have summarily rejected in a democratic process endorsed by their elected government.
Autonomous country. Many international experts have identified various models of political autonomy between large states and their former colonies. Among them, noted scholar James Crawford stated in 2005 that there is a wide range of choice, particularly in the case of autonomy, which can cover a spectrum of possibilities from virtual independence to virtual integration. The people concerned may be and have a right to be free. He further states that such arrangements were the results of negotiations with respect to an individualized arrangement mutually agreed by territory and administrating power. The governance model of autonomy has been raised by the Netherlands in the context of a transformation to a Commonwealth structure composed of Holland and the present respective autonomous countries of the Caribbean, namely Aruba, Curaçao, and Sint Maarten. This was raised as early as 1990 by Dutch Minister Hirschberlin, who presented a framework for a Commonwealth constitution which called for the islands of the autonomous country of the Netherlands Antilles to be divided into two separate autonomous countries comprised of Curaçao and its neighboring Bonaire as one autonomous country, and the Windward Islands of Sint Maarten, Saba, and St. Eustatius as a second autonomous country. The actions of Berlin reflected political discussions underway at the time towards the transfer of power to the overseas territories. Indeed, the former Netherlands Antilles had already been described by Hillebrink 2008 as a constitutional association with the Netherlands. Eustatius' quest to become an autonomous country within the realm of the kingdom is based on United Nations General Assembly Resolution 1541, which recognizes the overseas territories are free to choose for an autonomous arrangement with their former colonial power or with any other independent state. It can be further argued that an autonomous arrangement with the Netherlands, based on the guiding principles laid out in the Resolution 1541 of 1960, is feasible within the existing framework of the Netherlands Kingdom and would be consistent with the expressed wishes of the people of Sint Eustatius as expressed in the 2014 referendum.
Autonomous country, elements of a draft constitution. Sint Eustatius desires an autonomous arrangement that complies with Resolution 1541, which recognizes that the autonomous arrangement should be one which respects the individual and the cultural characteristics of the territory and its people. Sint Eustatius therefore views the following elements of a station constitution. A. Sint Eustatius as an autonomous country would remain part of the Kingdom of the Netherlands. B. The kingdom would consist of 5 rather than 4 equal kingdom partners: Aruba, Curacao, St. Martin, Sint Eustatius, and the Netherlands. C. The citizens of Sint Eustatius would retain the Dutch nationality, consistent with the nationality of the other autonomous countries of the kingdom. D. Sint Eustatius would have its own constitution detailing its government structure, consistent with the constitutions of the outer autonomous countries of the kingdom. E. Sint Eustatius would exercise legislative and executive power over its internal affairs. Accordingly, the kingdom government would have no authority to annul or enact legislative or administrative acts regarding internal matters of Sint Eustatius. This does not preclude the provision of technical and other assistance which may be provided to Sint Eustatius by mutual consent. F. The timetable for the devolution of powers from the Kingdom of Sint Eustatius as an autonomous country within the realm of the kingdom shall be determined by negotiation. At the request of the Sint Eustatius Parliament, created by the Constitution, one or several of the kingdom partners may temporarily assume responsibility of identified competencies for a defined period while the capacity is developed by the competency to be administered by the government of Sint Eustatius, after which time the temporary competencies would be phased out over a transitional period mutually agreed upon. G. Any decision regarding internal tasks temporarily executed by one of or several of the kingdom partners would require the approval of the Sint Eustatius Parliament. H. Sint Eustatius shall be represented by a minister plenipotentiary in the Kingdom Council of Ministers, in a similar fashion to the ministers plenipotentiary of other autonomous countries in the kingdom. I. There would be the establishment of a joint mechanism for the resolution of disputes between the Station Parliament and the Kingdom Council of Ministers regarding kingdom matters affecting Sint Eustatius, to ensure mutual respect and cooperation as reflected in the Kingdom Charter. J. The role of governor, whose appointment would be confirmed by the Parliament of St. Eustatius, would serve as the representative of the kingdom government and shall have no authority to unilaterally intervene in the internal affairs of St. Eustatius, including in the areas of supervision and legislation. This would not preclude the provision of advice and consultation by mutual consent between the kingdom and St. Eustatius. K. Since the governor's duties would be limited to serving as the representative of the kingdom, the appointment would be made by the kingdom, but subject to confirmation by the Statia Parliament. See preceding paragraph. L. St. Eustatius would establish a budget of revenue and expenditure according to its budgetary rules as approved by the St. Eustatius Parliament. M. St. Eustatius would establish a financial supervisory mechanism to monitor compliance with its financial obligations and in accordance with its budgetary rules. N. As an autonomous country, St. Eustatius would have the authority to join in its own right relevant international organizations as a member, associate member, or observer as appropriate, including but not limited to sub-regional and regional groups such as the Organization of Eastern Caribbean States, the Caribbean Community, the Economic Commission for Latin America and the Caribbean, the Association of Caribbean States, and relevant economic and technical organizations of the United Nations. St. Eustatius will maintain its current overseas countries and territories status with the European Union.
E. Critical considerations. Assistance in capacity building may be requested from the relevant international organizations, including regional, sub-regional, and United Nations organizations, to gain the necessary training to meet the demands of the new status. Similar assistance in capacity building may be requested from the kingdom government on the basis of mutual agreed terms. The timetable for the assumption of competencies will depend on a number of factors such as the level of resources available to support the assumption of competencies, internal affairs, the prevailing economic situation. In this connection, a comprehensive economic development strategic plan would be developed in consultation with relevant private sector and civil society stakeholders. It is anticipated that the conduct of the government of St. Eustatius' internal affairs will be financed through its budgetary process consistent with the comprehensive economic development strategic plan. It should include the identification and retention of current and future revenue generated by the economy of St. Eustatius. In this structure, all tax revenues generated locally would flow into the coffers of St. Eustatius. The official currency of St. Eustatius will be determined by St. Eustatius with the help of the appropriate experts. Consistent with Article 73b of the United Nations Charter, the Netherlands would be requested to provide budgetary support to St. Eustatius for an agreed period until it completes the transition to the assumption of the full complement of competencies in internal affairs. A review of the applicable consensus laws would be undertaken by St. Eustatius, and one or more of these laws may remain in place by mutual consent for a defined transitional period on the basis of 1. A clear definition of areas in which said laws would apply. 2. Exact nature of said laws. And 3. A mutually agreed sunset clause, bringing an end to the consensus laws. The activities of the Dutch government organizations, RCN, would be gradually eliminated, resulting in a cost savings to the kingdom, with such savings designated by neutral agreement for budgetary support to St. Eustatius as outlined above. As St. Eustatius transitions from the present status into an autonomous status, it is of paramount importance that a program of economic and technical assistance be negotiated in conjunction with the Netherlands, kingdom partners, and relevant international organizations.
The public entity status in the context of self-determination. A. The evolution of self-determination. At the creation of the League of Nations in 1920, the right to self-determination was of paramount importance. According to Corbyn, July 2012, the international community tried to deal with the dilemma of their territories after World War I, which had not achieved full self-government through the self-determination process. Self-determination as a principle was a term used in the Atlantic Charter 1941, in which President Roosevelt of the United States and Prime Minister Churchill of the United Kingdom declared that territorial adjustment must be in accord with the wishes of the people concerned. The self-determination concept eventually became part of the UN Charter, the first legally binding document that recognized the right to self-determination. Harris, 2004, page 112. Article 73 of the UN Charter created the obligation of countries which administer territories to develop self-government in those territories. The notion of self-government at the formation of the UN was largely undefined, and other instruments were needed to give further elaboration. Corbyn, July 2012, such as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, which state, all people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. These provisions are particularly important for St. Eustatius because Article 1 of the UN Charter grants people of non-self-governing territories the right to freely determine the political status. Administering territories such as the Netherlands are obliged to promote the right of self-determination in conformity with the UN Charter. Daves and Soons, 2011. According to various scholars, the right to self-determination is generally seen as a norm within international law. Issues of self-determination are addressed in various review bodies of international human rights mechanisms, including the Human Rights Committee, the Human Rights Council, the Committee of the Elimination of Racial Discrimination, the European Court of Human Rights. B. Does the Netherlands acknowledge St. Eustatius' right to self-determination? When the Kingdom Charter was created in 1954, no explicit mention was made of the right of self-determination for the islands of the former Netherlands Antilles, of which St. Eustatius was a part. However, the Netherlands at that time assured the General Assembly that it would not prohibit the overseas territories from leaving the Kingdom Constellation if they desired. The island's right to self-determination was formally recognized at the Round Table Conference in 1981, whereby the Netherlands recognized each island's right to self-determination. De Jong, 1989. In spite of the Netherlands' acknowledgement of the island's right of self-determination, there has been ambivalence on the part of the Netherlands. During a constitutional information session held in Rotterdam on August 12, 2010, when a participant asked if St. Eustatius would have a chance after the evaluation period to choose another political status, Dutch Ministry of Home Affairs and Kingdom Relations and Kingdom BZK Representative Alexander Dalen Noort alluded to the fact that even though then State Secretary Ank Bijeveld Schouten acknowledged the island's right of self-determination, the only other option available to St. Eustatius would be independence. Minister Ronald Plasterk portrayed a similar ambivalence in response to questions asked about increasing talks about referendum in Bonaire and St. Eustatius. He alluded to the fact that while the islands were free to choose a constitutional option of their choice, they would have to comply with options that the Netherlands deemed to be acceptable. To add insult to injury, the Dutch government has unilaterally started the process of embedding the public entity of St. Eustatius in the Dutch constitution. Such action, as was the establishment of St. Eustatius as a public entity on October 10, 2010, is in direct violation of the people's right of self-determination. It can therefore be concluded that while the Netherlands acknowledges the island's right of self-determination, the nature of an autonomous arrangement for St. Eustatius would have to be carefully negotiated, consistent with the international standards of full self-government.
C. Democratic deficits of the public entity status. According to UN Resolution 1541 of 1960, internal self-government can be achieved by emergence as a sovereign independent state, free association referred to as an autonomous territory within the Dutch constitutional framework with an independent state, integration with an independent state. US Resolution 1514 and 1541 clearly established the standards for political equality for territories wanting to achieve self-government. St. Eustatius was transformed by the kingdom into a public entity in the sense of Article 134 of the Dutch Constitution. However, the public entity status does not comply with the minimum standards of internal self-government in accordance with the said UN resolution due to the following. The public entity status did not come about as a result of the freely expressed wishes of the people of St. Eustatius. There is a lack of direct political representation within the Dutch Second Chamber, as a result of which the 25,000 inhabitants of the Best Islands do not have any influence on the political makeup of the Dutch Second Chamber. Lower social and economic benefits have been implemented on the Best Islands as opposed to any Dutch municipality in Europe. The inequality that exists between the inhabitants of the Best Islands and citizens in the metropole was also confirmed in a report written by the Christian Uni in September 2011 and is not in accordance with the international law. Additional democratic deficits were further confirmed in the evaluation report of the Peace Committee. D. The deficits that exist within the Kingdom Charter, past and present. The Kingdom Charter was put into effect on December 15, 1954, whereby Queen Juliana characterized the Charter as a monument of power that strength of mind, self-control, and wisdom can produce in the midst of turbulent times. As a result of the Kingdom Charter, the Kingdom of the Netherlands currently consists of 4 equal partners, which, in the words of the preamble word, take care of their own interests autonomously, manage communal affairs on equal footing, and accord each other assistance. In spite of the information listed above, various scholars have made reference to the democratic deficits that exist within the Charter when compared to Principle 7 of Resolution 1541. Dutch ministers retain the final word over kingdom matters, even though the Dutch Council of Ministers include ministers plenipotentiary from each of the autonomous countries within the kingdom. The autonomous countries do not have the right to amend their own constitutions, which are legally subordinate to the Kingdom Charter. The kingdom government has authority to intervene in the affairs of the autonomous countries. The kingdom government also appoints the governors in the autonomous countries who hold extensive powers to block their legislative and administrative acts. The current autonomous arrangement that Sint Maarten and Curaçao enjoy can be seen as an example of minimum autonomy in light of the issue listed above, but also in light of the fact that 5 kingdom consensus laws have been implemented as a means of guaranteeing good governance within the Dutch kingdom. This has led to a significant decrease in autonomy in these islands. One such consensus law relates to the final supervision of Curaçao and Sint Maarten. There is a board of financial supervision for said islands that consists of 5 board members who are appointed by the kingdom government upon the recommendation of the Dutch Prime Minister. This example once again illustrates that the autonomy that exists within the Dutch kingdom today is not in accordance with UN Resolution 1541.
Sint Eustatius re-inscription on UN list of non-self-governing territory. A brief factual background. Removal Netherlands Antilles and Suriname from UN list. The Dutch colonial presence within the Dutch Caribbean, Aruba, Curaçao, Bonaire, Sint Maarten, Saba and Sint Eustatius, Suriname and Indonesia dates back to the 18th century, whereby the islands were used as trade centers for the Dutch Empire. Slavery within the Caribbean territories was abolished in 1863, long after England 1834, France 1848, and Denmark had taken this step. Indonesia became independent in 1949 against a backdrop of new emergent attitudes towards the decolonization of colonial territories among Western states. Dutch decolonization policies, which did not run smoothly, led to the creation of the Kingdom Charter in 1954, after Indonesia obtained its independence. At its inception, 1945, the United Nations regarded the issue of decolonization as one of its important functions. Resolution 66 of 14 December 1946 listed the original 72 non-self-governing territories, including the former Netherlands Antilles and Suriname, which later became independent in 1975, and further refined the concept of self-government. As a result of this resolution, the Netherlands had promised to transmit information to the UN regarding the island's economic, social, and educational conditions, as listed in Article 73 of the Charter. In regards to developments surrounding the Kingdom Charter, the Netherlands on March 1955, in pursuance of the terms of Resolution 747, informed the Secretary General in writing of the constitutional developments leading to the promulgation of the Kingdom Charter on December 29, 1954, comprising of the Netherlands, Suriname, and the Netherlands Antilles. The Netherlands enclosed a copy of the Charter together with an explanatory note. The Netherlands explained that its territories had attained a sufficient measure of self-government, even though the people were not directly consulted. This led to intense debates regarding the role of the governor. Many countries, including Iraq and Guatemala, were not convinced that Suriname and the Netherlands Antilles had attained a full measure of self-government in accordance with Chapter 11 of the Charter, and in particular, the factors laid out in Resolution 742 and other relevant UN resolutions. Despite the contentious circumstances surrounding the above-mentioned developments, the vote to cease the transmission of information in accordance with Article 73 was approved with 21 votes in favor, 10 against, and 33 abstentions, effectively removing Suriname and the Netherlands Antilles from the list of non-self-governing territories on December 15, 1955. Official UN documents reveal that many countries did not consider that the Kingdom Charter had met the standards for decolonization adopted by the UN General Assembly 2 years earlier, and which would be laid down in Resolution 1541 a few years later. The Netherlands used Resolution 945 as justification that the islands had been decolonized. However, said resolutions does not affirm that the former Netherlands Antilles had received a full measure of self-government under Article 73. It merely removed the requirement of the Netherlands to regularly submit information regarding its colonies to the UN under Article 73. It preserved the UN authority to decide whether a non-self-governing territory, such as the Netherlands Antilles, then, and Sint Eustatius now, has attained a full measure of self-government.
Reinscription. As was stated in the previous chapters, the establishment of the public entity status was not in accordance with the relevant UN resolutions. It was also argued that, based on the information provided above, the then Netherlands Antilles should not have been removed from the UN list of non-self-governing territories. In light of the information provided in this document, the political representatives of Sint Eustatius, with the support of the various civil society organizations, believe there is a sufficient rationale for the reinscription of Sint Eustatius on the list of non-self-governing territories. Some of the proposed short and medium-term actions towards the reinscription, as were listed in the position paper entitled The Right to Self-Determination of Bonaire and Sint Eustatius, Achieving a Full Measure of Self-Government by 2020, are included here. The dissemination to exchange of additional information with Special Committee on Decolonization, C24. formal hearing of delegations of the Netherlands, Bonaire and Sint Eustatius, inter alia, NGOs, Noske Bonaire and possibly Brighter Path Foundation, and Pro Statia on Sint Eustatius, in consultative processes of the UN Economic and Social Council, the Permanent Forum on Indigenous Issues, and other international organizations dealing with human rights related issues. Amendment of the Kingdom Charter. Proposals to this effect are already available and have been circulating in parliamentary circles in draft form. A comprehensive plan of approach towards regional engagement and the move towards reinscription, along with increasing regional awareness of Sint Eustatius' situation and incorporation of the above-mentioned action points, will be further worked out in consultation with advisors in a separate document.
In the white paper, UN Resolution 1514 is mentioned. This resolution is talking about territories going from under the colonial power, the so-called administrative power, to total independence. Remember that in between these extremes in the Dutch kingdom, we have the country status. The country status is the status of St. Maarten, Curaçao, and Aruba. This is the association the Netherlands agree on for the Dutch kingdom. Coming back to the UN Resolution 1514, this resolution is divided in 7 declarations. For Statia, Declaration 2 and 5 are the most important. Number 2 says, all peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. At the moment, that is not the case. One example is the medical school. We could not keep the medical school, or you can say the medical school could not remain in Statia because they did not comply with Dutch law. So instead of pursuing freely Statia economic development, Statia is pursuing the economic development of the Netherlands. The same is to say with the well-known cultural issues. This is a violation of UN Resolution 1514, Declaration 2. Let's look at Declaration 5. Immediate steps shall be taken in trust and non-self-governing territories or all other territories which have not yet attained independence to transfer all power to the people of these territories without any conditions or reservations, in accordance with their freely expressed will and desire, without any distinction as to race, creed or color, in order to enable them to enjoy complete independence and freedom. So, Statia on their way to independence, that can be in 10, 20, 30 years or maybe longer, the people of Statia need to experience all freedom to make any choice they want, a choice as to be a country within the kingdom. And the colonial power should not put any obstacle in the way. That is, the Netherlands should not make it harder for Statia to exercise their right of self-determination. And with locking Sint Eustatius into the Netherlands in the coming months, the Dutch government is doing just that. They are making it harder for Statia to exercise their right to self-determination. This is also a violation of UN Resolution 1514 and now Declaration 5. A next UN resolution that also appeared in the white paper is number 1541. This resolution, Resolution 1541, is built up in principles. Let's look at Principle 7. Free association should be the result of a free and voluntary choice by the people of the territory concerned, expressed through informed and democratic processes. It should be one which respects the individuality and the cultural characteristics of the territories and its peoples, etc., etc. Statia made clear on May 5, 2005, that Statia wanted to have direct ties with the Netherlands. That is also being associated with the Netherlands, but different than country status. Did the Netherlands comply with the freely expressed will of the people of Statia? No. The Netherlands gave Statia what the Netherlands wanted: partial integration. So you go and make a choice. When the Netherlands is doing like they're complying with the resolutions of the UN, but when they don't like the outcome, they give you what they want. Let's look at Principle 9. Integration should have come about in the following circumstances. A. The integrating territory should have attained an advanced state of self-governing with free political institutions so that its peoples would have the capacity to make a responsible choice through informed and democratic processes. The integration should be the result of the freely expressed wishes of the territory's peoples with full knowledge of the change in their status, their wishes having been expressed through informed and democratic processes, impartially conducted and based on universal adult suffrage, that is, the right to vote. The United Nations could, when it deems it necessary, supervise these processes. So, being half integrated, that is, the public entity, was a violation, and if the Netherlands pursue to lock Statia in the kingdom, that will make Statia full integrated, that will be another violation of Principle 9 of UN Resolution 1541. Any change of status has to be a choice of the people of Statia, not a choice of the Dutch government. Finally, the UN resolutions are on the internet and everyone can read them. We of the Constitutional Committee did not make them up. These resolutions are a way of the territories that once were colonies to get out from under the colonial power and pursue their own economic, social, and cultural development. We advise everyone to read the white paper, inform yourself, and know what you want for yourself and for future generations.